Hi, I'm Corinne Kirkendall, the EVP of Compliance and Regulatory Affairs at Pastime. It's my pleasure to welcome you to the third and final session of NIADA's webinar series. Over the course of this series, Patrick has been so gracious to help us build a strong foundation from the FTC priorities to FCRA to Regulation Z. And today we bring it all together with a focus on ECOA, the Equal Credit Opportunity Act, and Regulation B. These are critical areas that direct impact of fair lending practices and compliance expectations across the country. Pastime will continue to be a leader and a provider in this industry, as well as in GPS and starter and up devices. If you're looking for a strong device provider, please consider to reach out to us for your business needs. We appreciate that. So we're a proud sponsor of this series, and thank you for having us join, and let us begin.
Well, thank you very much, Corinne, and thank you to everyone online today for taking time out of what is clearly a busy day to learn a little about the Equal Credit Opportunity Act. As Corinne noted, this is the third in a three-part series. Previously, we went over the FCRA, and then we also did the Safeguards Act with a special Q&A with the FTC. Just a couple housekeeping items before we get started. As I've said previously, nothing that you hear today constitutes legal advice. If you do hear something today that triggers a concern within your dealership and you feel like you need to consult either a legal professional or a compliance professional, by all means, reach out to me discreetly. I'm more than happy to identify somebody that is within your region and also within your budget. Second, all of these webinars are being archived on the NIADA's YouTube channel. The first two are already up, and we'll just do a little bit of cosmetic work to this one, and we should have it up in short order as well. And we hope to continue this process and these series moving forward into the future with new topics. So with that said, we will jump right into it. And Yenny, if you could put the slide deck up, that would be fantastic. All right. So here we are, the Equal Credit Opportunity Act, otherwise known as ECOA, implemented through Regulation B. Next slide, please. And once again, just want to thank Pastime for their generous sponsorship of not just today, but the previous two webinars as well. We're very grateful for their partnership. And the next slide. As in the past, because this is a compliance webinar, we're just going to defer all questions to have them submitted in writing. And as I have in the past, I commit to get you precise, accurate responses in writing to everybody who's participating today, regardless of whether or not you ask the question. You will receive an answer to the question. So you can look forward to those in the very near future. Next question, next slide, please. Okay, ECOA, here we go. This is just a quick walking tour of ECOA. A little bit newer than the FCRA, but not by too much. The FCRA was, of course, a Nixonian regulation. This is a Gerald Ford regulation. He signed it into law in 1974. ECOA, when it was originally signed into law, it was very limited. It really only covered discrimination based on sex and also marital status. It turns out that there were a lot of creditors that were requiring women to be co-signers. It was a normal demand. So over the years, ECOA was expanded to include additional protected classes, which we will go over momentarily. Again, it has been expanded over the years. The most material change, of course, happened in 2010 when the primary rulemaking authority and enforcement was transferred from the Federal Reserve over to the CFPB. Of course, it prohibits lending discrimination based on a number of protected classes. This is the majority of them here. We'll go over them with a little bit more detail as we go through the slides, but it's sex, marital status, you know, person's religion and creed and their age with certain qualifications and a few others. As I noted, the CFPB maintains plenary enforcement authority. So does the FTC. The Justice Department Civil Division also maintains some enforcement authority over ECOA. And of course, because ECOA is not just limited to auto lending, the federal banking regulators maintain enforcement authority as well to ensure that there is appropriate fair lending compliance across the entire waterfront of credit availability in the United States. It is codified at Part 12 of the Code of Federal Regulations, Part 102. Happy to send a link to that if anybody would like to see it. It makes fun bedtime reading, but that's the implementing regulation for all supervised entities, including auto dealers that act as creditors. So next slide, please. Now, the big normative, how does it apply to auto dealers? Much like I said during last week's webinar, unless you are exclusively selling cars for cash, chances are ECOA applies to you. So if you are in the business of creating financing, checking credit, or setting terms for a loan, you are considered a creditor under the Equal Credit Opportunity Act. I'll break it down with a little bit more specificity, starting with the next slide, please. So I know a lot of our members are buy here, pay here dealers. You are very clearly a creditor as doing your in-house financing. So the full menu of ECOA and Reg B obligations apply to you and your compliance obligations. That includes adverse action notifications where appropriate. If you're declining or offering credit under terms that are different from what was originally presented, those apply. We'll go into that in a little bit more detail. Adverse action notices, if you tuned into last week, you'll notice that there's a little bit of a derivative obligation there between ECOA and FCRA. Both have adverse action notification requirements. There's just different seasoning on each. There's also record retention obligations, which we'll go into in a moment, but you do have to maintain those applications for a defined period of time. That's part of your regulatory obligations. And if you are examined or investigated at either the federal or state level, this is the type of information that they will seek from you to ensure that you have all of that information, not only on file, but safely secured. Next slide, please. Okay, and then we have the retail dealers. Those are those dealers who I do not have to tell you this, but I will say for the purpose of this webinar, those are the ones that arrange financing through indirect lenders. And if you're submitting those credit applications to finance companies or other lending institutions, that creates ECOA responsibilities for you. Even if you don't fund that loan, if you are arranging that credit on behalf of a third-party creditor, you do have ECOA obligations and you need to take them seriously. Those obligations are borne on both you and the indirect lender. So the subjectivity is the same, but there are a little bit of differences. That's why it's ensured that those of you who are retail dealers, you likely enjoy a very symbiotic relationship with your lenders. It's important not only from a crediting standpoint, but really from a compliance standpoint when you look at something like ECOA to make sure that there isn't uninformed assumptions that one party is doing something that the other party should be doing. Now, the CFPB and the FTC, and certainly the state regulators for that matter, have taken enforcement action out against dealers and indirect lenders in the past. So this is quite important. Those of you who have been around the block long enough will probably remember the Ally Auto CFPB indirect lender ECOA case from, I think it was 2016. I was actually at the CFPB at the time. That was a pretty big deal. That was grounded in disparate impact, and it was based on dealer reserves being artificially inflated for certain protected classes. So there certainly is a rich history of these regulators going after car dealers for failure to comply with the basic tenets of ECOA. Next slide, please. Okay, so there are 9 basic protected classes that are covered under ECOA. As I noted at the outset, these have evolved over time. The ones are pretty obvious: race, color, religion, national origin, and sex, and marital status. A good rule of thumb when you're training your staff is really treat everybody the same with a level of facial neutrality when they walk in the door, regardless of what they look like. It's really the activity test is when you start to look at their credit and you look at credit worthiness and credit fitness. But any of the 9 protected classes should not be a basis until it's time to pull their credit and make those determinations. The last one's a little wonky, so let me just explain what that means. If a consumer has exercised a good faith effort to exercise their consumer rights, that's a protected class as well. For example, if they contested a trade line on their credit score, on their credit report, that of course is permissible under FCRA. If you were to use that as a reason to discriminate against them for a new line of credit, that is actually an actionable offense under ECOA. So just be very mindful of the fact that if a consumer is exercising their rights under the 13 enumerated consumer financial protection laws, that too is a protected class. That does not seem as though on the surface, but it is very much the case, both in statute and in the implementing regulations. So it's important to be mindful of that as you're looking at people's credit fitness. And again, just discrimination on the basis of any of these is prohibited and should be very carefully thought through. Next slide, please. Okay, so now we'll just talk a little bit about the types of prohibited conduct that both the statute and the implementing regulation outline. Discouragement, and we'll talk a little bit about this more shortly because there's some changes here. But in essence, you can't discourage a person from applying for credit based on any particular protected class. As I mentioned earlier, reasonable applicant standards, the best way to look at that is when somebody walks in the door, again, you treat them like no different. 5 people walk in, they're all the same. It's not until you start to look at their individual credit histories, credit worthiness, credit fitness, that's where things start to deviate. You need to treat everybody like a reasonable applicant from the get-go. You can't inquire about any information that is based on somebody's protected status. I won't read them again, they're in front of you, but that's just important rule of thumb to know that none of this information should be a factor when you're making the credit decisions. The credit decisions should really be based on what that credit history is, both good and bad. And then of course you can't, in different standards, you want to make sure that you're not using any type of disparate treatment. I like to use the term disparate treatment in this regard. I know that's primarily an employment law term of art, but if you're treating somebody differently or inconsistently, that it really is a type of disparate treatment in the credit appropriate space. So you just need to be very careful of that and make sure that you're being very mindful of people's protected class and ensuring that as you are making these decisions, that you're not doing anything that is prohibited, under the law. Okay, I would also note that when it comes to questions about a person's spousal status, that's also only permitted if the spouse is jointly applying for that credit as a co-signer. Otherwise, it's not a permissible use or a permissible question to ask. That's not always as obvious as it should be, so I just wanted to point that out before we move on to the next one. All right, next slide, please. Okay, a few other areas that are prohibited conduct. Discrimination on terms. You obviously cannot offer one person a different interest rate or require a higher down payment or a lower down payment or different loan terms based purely on the fact that there's protected class. I'll say it again for about the 4th time. It needs to be facially neutral, and it's the facts and circumstances of their credit history that are going to dictate those terms. You cannot require co-signers, whether it's a spouse or a parent, unless the applicant's credit worthiness standards do not meet your dealership's standards for credit fitness. And then again, as I mentioned earlier, retaliating against somebody for exercising their basic consumer rights is also a prohibited conduct, and you need to be sure that you're not doing that. Anybody who's in the compliance world will understand if somebody is asking a question that is grounded in their rights under consumer financial law. And that's just something that should be also, and we'll get into this in a moment, should be really part of the training and part of your compliance manual, just to make sure that people that don't do this on a day in and day out basis are familiar with this one, because it's not as apparent as it should be, but it's treated no differently than discrimination based on sex or race or origin. Next slide, please. Okay, as I mentioned earlier, much like FCRA, the Equal Credit Opportunity Act also requires adverse action notices. They're fairly prescriptive, just like FCRA. You want to make sure that when you are filing the adverse action notices, you're doing so in a way that is consistent with what is required under the reg and the statute. The basic reasons why one would do so is the obvious one: you've denied their application for credit for whatever the circumstances may be. The existing credit terms have negatively changed. A good example of that would be if you find yourself in a spot delivery scenario and things have changed after the fact, that would trigger an adverse action notification. And then, of course, if you've made a counteroffer to the consumer and that counteroffer has been rejected. Now, not required under either the statute or the regulation, oftentimes you will see practitioners that will make the counter offer and the adverse action notification at the same time. It's more of an efficiency exercise. It's not required, but it's a good way to make sure that you're covering down on both of those obligations at the same time. So that's not guidance or advice. It's just something that other practitioners do, and it's something to consider if you're not doing already, just purely as a matter of efficiency. And then when it comes to timing, just be mindful of the 30-day clock. That 30-day clock will probably sound familiar to some of you folks who have attended previous webinars. 30 days is what the federal government believes is a reasonable period of time. You just need to make sure that you make that notification after the application has been completed. And if there is a cosigner on that loan, please make sure that that cosigner also receives the adverse action notification along with the primary borrower as well. This is an area where people tend to slip up. It's an unforced error. Just make sure it's well documented, and when you're going through your checklist of what needs to be done, just to ensure that both the applicant and the co-applicant are receiving them at the same time. Next slide, please. All right, continuing right along. Once again, it's prescripted. I believe that that's always best, that you can cite back to either the statute or the regulation to ensure that you're following through on exactly what's expected of you. You need to make sure that when you're taking action, it's very specific about what it is. Don't use vague or unclear language about why you're denying the credit. Just be very forthcoming. State the facts and the circumstances so it's easily recognizable. It's easily comprehended. There's nothing in there that could create a follow-up activity on behalf of the consumer that could create unnecessary paperwork for you and your dealership, whether it's in the form of a consumer complaint or something else that's coming from a state or a federal regulator. It also has to include the ECOA notice. Now, the ECOA notice you can find, the CFPB has it up on their website. There's a few things on there. There's a global anti-discrimination statement that's included in there, but it also sets forth the provisions that are included in Section 701A of ECOA that just provides a little bit more color and perspective about what their rights are under the law. You need to have the address of the functional regulator that your dealership falls under. And then, of course, the identification of the creditor itself. In this case, that would, of course, be your dealership. Now, it's important to note that if you are a retail dealer, both the dealer, as I mentioned earlier, has ECOA responsibilities, as does the lender of choice. So a good rule of thumb and a good best practice is to have regular coordination with those indirect lenders to make sure that everybody is following through on what their responsibilities are. Chances are that's already happening because if you're working with various lenders, you are probably in regular contact with them. Assuming that is the case, I would recommend adding this to your regular check-ins with them just to make sure that their ECOA compliance framework is similar to your ECOA compliance framework where there is appropriate overlap. And I also note that there are model forms available on both the FTC and the CFPB's website. If you wish to download them and use them for accuracy's sake, I can't confirm, but I will about the FTC. But I know that the CFPB also offers forms in other languages as well. Certainly Spanish. I think simple Chinese is also included in there, and a few of the European languages as well. I'll confirm that, but that's a good resource for you to pull from should you be looking for additional information when it comes to some of these forms and meeting the adverse action requirements. As I noted earlier, FCRA has a similar framework in place. So it's just good to cross-check both of those because there's a good chance if you're filing one, you're filing the other as well. Okay, next slide, please. All right, so some common violations that we see in the ECOA space when it comes to non-compliance is as I briefly touched on the previous slide, just assuming if you work with indirect lenders that they're sending the notice, but not confirming that that's happening, not sending the notice when the dealer is doing the in-house financing and making that decision unilaterally. And then I mentioned about spot deliveries earlier, failing to send those notifications as well when you have to unwind a deal, and that results in an adverse action notification. These are just a few things that, as you're thinking through whether updating your compliance manual or creating a new one, these are just some of the areas to be mindful of and think through as you're determining exactly what that framework will look like. All right, next slide, please. Okay, discouragement. And we're going to talk a little bit about discouragement at the end because there have been some regulatory developments. But discouragement is exactly what it sounds like. You are discouraging an applicant from applying for credit. And that is verboten under ECOA for protected status individuals. There's a couple of examples here I put here. It's painful for me to read these out loud, but I'm doing it to be demonstrative. You know, you can't tell somebody in a protected class, oh, you probably won't qualify. They could draw a conclusion that you're making that determination based on how they look, what their sex is, whether they have an accent, the list goes on and on. Or if you were to say something like, this program isn't for people like you, you know, you could have knowledge of the fact that the applicant is a recipient of social services, and that is part of their income, you know, making a statement that could somehow insinuate that because they're receiving public assistance, you know, this is not for them. That is a prohibited form of discouragement and can find yourself facing an enforcement action if you were to be reported on and the facts supported the claim. Most importantly, it applies to verbal, written, and digital. I put an asterisk by this because we'll talk a little bit at the end about what discouragement looks like starting in July, but just be mindful of this. The changes are a little bit confusing, and when we go over them, I'll talk about some of the things that I'm going to be seeking moving forward so I can make sure that you all who are responsible for complying with this will have the best information available to you. Okay, next slide, please. Okay, advertising and marketing. It also, you need to be, you know, facially neutral is the best way to describe it. I think folks are aware of disparate impact. This is something that is, you know, talked about quite a bit when it comes to ECOA. For those of you who don't, you know, a basic definition of disparate impact, it's policies that appear to be neutral on their surface, but they are disproportionately disadvantage certain protected groups, those 9 that we just listed. A couple of examples of those would be offering markups that are inappropriate, or higher down payments, or add-on fees to cars. Those are examples of disparate impact violations, but so is advertising and marketing. That's why I mentioned that. If you are targeting your advertising just in specific communities, if I drive 3 miles from where I'm sitting right now, I'll find myself in a town called Chevy Chase, Maryland. It's one of the most affluent neighborhoods in Maryland. If you're only advertising and targeting your marketing in Chevy Chase, that could be viewed as a disparate impact exercise. Or implying in your ads that you give preference to certain demographics, that too would be a violation under the advertising and marketing provisions of ECOA. So just be very mindful to ensure that as part of your advertising and marketing strategy, you're doing everything you can to be neutral and non-discriminatory. Okay, next slide, please. Now, maintaining a compliance program is key. I have no doubt that many of you, if not all of you, already have them on your books. If you don't, I encourage you to do so as soon as possible. As I've said in past webinars, these are the types of information that your regulators will seek from you when they open up a file or an investigation. You need to have written policies and procedures, which include, these are the main ones, you know, documented underwriting standards, you know, what you use to make credit determinations, what your procedures are for sending adverse action notifications, which we went over earlier, the who, what, when, where, and why. If you do dealer reserves, what are the policies for that? Just make sure it's appropriately characterized and enumerated. And I talked a little bit earlier about the fair lending policy statement, which you can find on CFPB's website. That should also be a part of your policies and procedures. And then, of course, having those policies and procedures, the next logical step is ensuring that your employees are aware of what those policies and procedures are, and that comes by way of appropriate training. Training should be at least annually. I know that a lot of you experience turnover, so if you want to do it as part of the onboarding process, that's definitely a good practice. But as a dealership-wide exercise, it should be done at least annually, and that's primarily for the F&I staff. But anybody that you believe would benefit from this, anybody who's interacting with customers, I think it's a good practice for them to be aware of what ECOA and Reg B require. It's just a good practice all around the board. Making sure people understand what types of inquiries could be perceived as a violation of the law, i.e. discriminatory, understanding how to appropriately and thoroughly fill out an adverse action notice, making sure that they have that training, and then of course, training on documentation and completion of records and records retention. That's critical as well, because the record retention policy is also prescripted under ECOA, and you want to make sure that you don't have, if you're not storing them for a time that's less than what's required under the law. Next slide, please. Okay, just continuing on. Monitoring and testing is a smart move. You should regularly looking at your pricing decisions, checking for disparities, making changes and cures to those disparities on the front end on a proactive basis. Nobody's perfect. There's always going to be slips. That's why it's important to do these testings, to spot check and to identify if there are areas that need changes. You do so before a regulator points that out for you. This isn't a mandatory part of the compliance program, but I think it's smart. If you do dealer reserves, it wouldn't hurt to just get a good sense of what the markups are looking like within the universe of the dealer community. You can do a statistical analysis of that. Of course, there are third-party vendors that will conduct this service on your behalf, and then just having a methodology that does a comparative of that and keeping that within your files. And then making sure, as we talked about earlier, since discouragement is such an important part of the prohibited practices, ensuring that you're monitoring to ensure that there isn't any inadvertent discouragement. It can happen innocently, but innocence is not an excuse for violating the law. So making sure that your staff is aware of what types of discouragement scenarios are off limits, and ensuring that they're following that is always good. It's always a good best practice. A lot of you probably use vendors. The one thing that I've said in the past 2 webinars, and I'm saying on this one again, if you use vendors, do appropriate due diligence with them. Lenders change hands all the time. They're bought by venture capitalists, or they're sold, or they merge with other vendors. There's no guarantee that one vendor's best practice is going to be the same as their previous parent company. So just review the arrangements that you have with them, and understand what their processes are through basic due diligence. And don't be afraid to point out disparities or shortcomings. You know what your minimum standards are, and make sure that it's contingent of working with this vendor, that their practices and policies are on par with yours as well. So there's no deviation from what you're doing at the dealer level and what they're doing for you as a vendor. And then, of course, doing regular audits and reviews is important as well. An annual fair lending audit by your compliance officer, or if you use an outside counsel, depending on your size and sophistication, is always smart. Have them kick that tire, take it for a test drive, see what the problems are, shake it a little bit, come up with a punch list of areas that are in need of review, that are in need of changes, that are in need of updates. No program is going to remain evergreen. If you are buying other dealerships, you're growing in size, or you're shrinking in size, your management change, your compliance officers change. These are all aspects that can affect your compliance program, and that's why it's important for you to take a look at it on a regular basis and issue spot and make changes accordingly. And then, of course, because nothing is static in Washington either, as we see more regulatory changes, whether it's in the form of informal guidance, affirmative new rules, which we'll talk about in a moment, frequently asked questions that carry the same full force of the law. We're expecting a body of FAQs from the FTC on pricing transparency. That's a great example of the type of information that you should be tracking, keeping a close eye on, and factoring it into your compliance program. All very important information. Next slide, please. Okay, so these are just some practical, I'm going to go over some do's and don'ts of some practical steps just you should be mindful of to keep yourself in compliance. And you can all read, I'm not going to read these to you, I'm just going to highlight the ones that really matter the most. The 30-day clock on the adverse action notification, that's critical. It is prescriptive, it's required under the Reg B. Please be sure to get it within that 30-day window. And if you are issuing an adverse action, specifically when it comes to a denial of credit, the consumer has a right to request the reasons, the facts, and the circumstances for that denial. They're on a 60-day clock. If they make that request, please remember, you have an obligation under law to respond to that with the information. So be mindful of both the 30-day clock for adverse action and the 60-day clock for any inquiry about why credit denial occurred. And again, just the most important one is clear and consistent credit standards to all applications without any regard to a protected class. The standards are set by you. They're going to be good. They're going to be bad depending on the individual applicant's credit fitness and history. But just be consistent and make sure that you don't inadvertently exercise a level of discrimination that could come back and haunt you by way of an enforcement action. And all of that really is based on that annual training that we just talked about earlier. Make sure your staff not only attends it, but takes it seriously. If you're using an outside vendor for this type of an exercise, chances are they're going to have some type of a quiz that you can take to make sure that you're actually following through and paying attention and passing that quiz. A good practice, not required, but something that you should consider depending on how big your staff is and how complex your organization is. Now, credit retention, you'll see that it says 25 months. I know it seems a little wonky. The reason why it's 25 months is because they want to make sure that you're maintaining these records for at least 2 years. And if you started at the end of 1 month, they don't want that 1 month to count towards the 24. So it's really 24 plus 1 to ensure that you have a full body of 2 years of records on the books. Making sure that your fair bill ending policy is well documented, and just monitoring your pricing decisions very carefully and methodically to ensure that you aren't inadvertently discriminating. And then again, if you've got notification requirements, be sure to do so thoroughly and completely. Next slide, please. And then the don'ts. A lot of these, again, are very obvious. If you're making fitness determinations, just don't ask about the protected classes. Discouragement, certainly don't use a person's perceived status as a protected class to discourage them from applying for credit. If a person needs a cosigner, make sure that that cosigner is being assigned because the person does not otherwise qualify for credit unilaterally. Do not ask for it because as a prophylactic measure, if you will. It can only be done if they've either sought it or it's required because they're not meeting your minimum credit, your credit underwriting standards. Ignoring and processing complaints against alleged discrimination. Take them seriously. If somebody is accused you of discrimination, the best thing that you can do is dispense with that as quickly as possible. If you're operating your dealership with integrity and within the accordance of the law, you've got nothing to worry about. Defend yourself vigorously and zealously, but do so on time. If you get an alleged, if you get a complaint, treat it with the utmost of seriousness and deal with it as quickly as you can. Trust me, it's in your best interest to get out in front of that as soon as possible, particularly if the person lodging the complaint has retained an attorney. And just making sure that your folks in F&I are hewing very carefully with the credit standards and operating appropriately when it comes to the documentation that are required under your dealership's rules and regulations. Adverse action notifications. This is an easy unforced error. Just make sure that you're issuing them within that time frame that we talked about earlier. And just retaining the credit information across the board. I don't think there's any way that you can retain too much information so long as you're making sure that you are retaining it in a safe and secure manner. You never know what a regulator is going to ask for if they come and investigate you or audit you, and it's better to have that body of information so you can be as cooperative as possible. Next slide, please. Okay, there's a whole bunch of enforcers out there that can come after you for non-compliance. We talked about the CFPB and the FTC. The Department of Justice Civil Division, they have enforcement authority. They have taken out ECOA cases in the past. They took out a lot of them during the Biden administration. We haven't seen any from the Trump administration, but past is not prologue. Who knows what the future has in store for us? And then, of course, state attorney generals. We just saw the Lindsay group. Of course, that was not based on ECOA violation, but we're seeing that the state attorney generals really are gearing up to fill that vacuum that's being created by a more attenuated level of enforcement at the federal level. And then, of course, private rights of action by harmed consumers. They have every right to get lawyers and come after you civilly. And then the damage can include both equitable relief, punitive damage, and you can be on the hook for paying attorney's fees as well. It's not uncommon to be sued over a discrimination case under ECOA. So everything that we've talked about previously is really a good way to keep yourself from this last part becoming a lived experience for you. All right, next slide, please. Okay, now for the fun part. There's been a lot of changes with respect to ECOA since the new Trump administration came into office. And I'm going to try and be as pedestrian as I can in describing them to you while qualifying it by saying, I think the regulators have some work to do in terms of making it clear exactly what these changes mean. But let me give you a quick verbal walking tour. So back in February of last year, among the series of executive orders that Trump administration issued, there was one that was put out on meritocracy, and it included a statement that the administration believed that disparate impact was a flawed legal theory. That's exactly what it is. It's a doctrine. It's not a statute. That in itself, for the lawyers that are on call will appreciate, can make things very confusing because there's no statute of limitations. Different lawyers interpret it in different ways, and it can be applied in different ways. Another part of that executive order included a directive to all regulators that enforce fair lending standards to immediately unwind any pending enforcement actions that they had pending that were grounded in disparate impact. So if you have been paying attention to what the FTC has been doing, you will recall last summer, the FTC unilaterally dropped a series of investigations that they had against some dealerships in Texas that were based on disparate impact claims. Shortly after that, the Department of Justice removed disparate impact from Title IX of the Civil Rights Act. They did that as a final rule, so it had an immediate effect. And then several months ago, the CFPB issued a notice of proposed rulemaking to make a number of material changes to Regulation B, including dispensing with disparate impact, and then also narrowing the definition of discouragement. As I said earlier, that NPRM went out several months ago. About 10 days ago, it was issued as a final rule. The final rule was issued as proposed, so they made no changes based on the comment period. And one of the areas that I found a little bit bemusing was a change that they made to the discouragement rule. They narrowed it to the point where it only applies to oral and written statements that a creditor, quote, knows would dissuade a consumer from applying. If I look confused, that's because I am confused by that. I feel like that is a trial lawyer's dream, because how do you prove something that was provided orally? So what I expect NIADA to do, as well as some of the other trade associations, is to find out if the CFPB plans on putting out some additional FAQs or guidance to further define exactly what this means, because on the surface, I believe that this is a lot of tripwires. And then also they expanded the protections to include that the changes apply to all applicants, including businesses. And then finally, one thing that I found interesting was that the CFPB under the Biden administration had put out some guidance on ECOA in 2023 that essentially said, if you were relying too heavily on an applicant's immigration status as part of the credit decision, that could be considered an unfair deceptive practice. You all might recall that last year, the CFPB rescinded about 67 pieces of guidance that they believed were inappropriate because they had not been subjected to the Administrative Procedures Act. Interestingly enough, they forgot to rescind this one. It wasn't until they started the rulemaking exercise to amend Regulation B that they realized that this one was still out there, and they quickly rescinded it just this past February. Most, if not all of you will know that immigration is an appropriate determining factor in a credit decision process. If an applicant came into a dealership on a student visa, for example, and they had 6 months left, I mean, you're not going to give them a 60-month loan when you know that they're going to go back to their home country in 6 months' time. So it is a determining factor. So it's good to see that that guidance has been lifted, because I think that it created a lot of unfair credit decisions that were made by not just car dealers, but anybody else subject to ECOA on the basis of a UDAP threat. Next slide, please. Okay, so I just want to point out one last thing, which is it's great that we see the CFPB and the FTC taking affirmative steps to acquiesce around what the administration is asking them to do. That's great. We should always embrace opportunities to reduce episodes of overregulation. That being said, nothing that the CFPB recently did preempts state-based fair lending laws. The point that I like to use to illustrate it is New Jersey just had a change in governorship. They went from Phil Murphy to Mikey Sherrill. During the transition from Governor Murphy to Governor Sherrill, which included a change in attorneys general, in that period of time, the state of New Jersey codified a regulation making it abundantly clear that disparate impact was still an enforceable claim under the state's fair lending laws. So please be very careful, depending on what state you operate in, to do a good, thorough scrub of what your state fair lending laws are, and don't just rely on what's required at the federal level, because you may be compliant at the federal level and at the same time find yourself out of compliance at the state level. So it's just a good belt and suspenders exercise to embrace the fact that we're seeing less regulation at the federal level, but that does not in any way reduce your obligations at the state level. They both can come with the same amount of enforcement power, and in some cases, the states could even be worse. And of course, the bottom line is, anytime you have an enforcement action taken out on you, that comes with reputational consequences, and that's something we should endeavor to avoid as much as possible as well. Next slide, please. All right, I want to thank Pastime once again for their generous support of this series. They're great partners, and it's always great to collaborate with them. As I noted, we will make this webinar available on our YouTube channel. The other two are up. Watch them, get us the clicks. We like them. If you have questions that you have not put into the chat, feel free to reach out to me. I really am at your service. I take my job very seriously. I really enjoy engaging with dealers. I want to make sure that you all are on the right side of the law. So if you have questions, just reach out to me. There's no such thing as a stupid question. And if I don't know the answer, I'll find out and I'll get you the correct answer. And that concludes today's webinar. Thank you very much. And I really appreciate everybody's time. And look forward to a new set of webinars in the near future. With that said, thank you very much, and I hope you have a great rest of your week. Bye-bye.